Hey guys, welcome back to today's video. This is not your average courtroom case. This is one of those situations where the entire room feels like it's operating on two completely different realities. On one side, you have the legal system trying to establish basic facts: names, identity, responsibility. On the other side, you have a defendant who appears to reject the fundamental structure of the court itself, repeatedly reframing simple questions into complex ideological arguments about trusts, titles, and identity.
The whole name?
Beneficiary.
Oh, he done this before.
What's his name?
The beneficiary.
Yeah. First name is the beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking what your name is.
my name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm
If so,
gonna recall him. Bring up somebody else. Put him aside. We'll call him at the end. Sir, is your name the beneficiary, Kevin Teron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I ask the questions here. You give me yes or no answers.
You're asking for my permission
I ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin.
Really?
Yes, Your Honor.
Really?
It is you that
Really?
is Kevin Pollard. Yes, Your Honor.
Kevin Pollard.
You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
I have. Can I speak to the clerk before we go any further?
You know what? I'm gonna put you in timeout. Get your mind right, Mr. Pollard.
Yes, sir. Can I have the clerk present, please, Your Honor?
Don't give in.
Right away, you can feel the courtroom hitting a wall that it cannot easily move past: identity. What should be the simplest part of any legal proceeding becomes the first major obstruction. Instead of confirming a name, we're suddenly hearing references to beneficiary, trusts, and repeated deflections that prevent direct answers. From a legal standpoint, this is critical because courts cannot proceed without establishing who is actually before them. But from a behavioral standpoint, what's more interesting is the strategy being used. Refusal to engage in direct identification, replaced with layered ideological responses.
That's no problem. Can I have the clerk present, please?
Hey, sir, I'm magistrate Chartea. DDC.
Excuse me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera one, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the state of Michigan versus Kevin Theron Anthony Pollard. who
Your
is
Honor,
listed by DDC as Kevin Pollard. However, the gentleman has identified himself as the beneficiary.
You representing as Kevin Pollard today, Your Honor.
Pollard,
I'm not.
Mr. Pollard, now, as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Pollard, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm going to enter plea of not guilty. Court dates are February 2nd, 2024. It is a probable cause conference, followed by preliminary examination, February 8th, 1:30 p.m. Both matters are in front of Judge King. The probable cause conference, it is at 8:30 in the morning. Mr. Beneficiary, you should not talk over to the court. I thank you very much.
You are under oath and you are on record. And I'm asking you,
beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the judgment.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk. I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct 1st degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot who, the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that the Mr. Pollard touched her, rubbed her, he says, okay? He said, accidentally is what he's trying to tell us what happened. The situation is she's told the...
At this stage, the judge is no longer just asking questions. They're trying to regain control of a conversation that is slipping into circular logic. What should be a straight exchange becomes repetitive, almost like 2 people speaking on completely different frequencies. The key issue here is that the defendant is refusing to anchor himself to a legal identity in a conventional way. And while that may sound abstract, in court it creates a serious procedural blockage. Without identity confirmation, everything else, charges, rights, representation, becomes harder to process.
Thank you, Your Honor. I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he did not sexually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard, is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed. They were dismissed without prejudice. Okay, this court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today is the 26th. January 29th, 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a predator in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the unaffordable bond redetermination for this Monday, January 29, 2024, 9 o'clock in front of Judge McConicle. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pretrial,
Talk to the gentleman.
Now the dynamic shifts noticeably. The judge stops engaging with the circular responses and starts asserting procedural authority. This is an important moment because it marks the transition from attempted clarification to controlled directive. In courtroom environments, once the judge begins limiting responses to yes or no, it signals that the court is no longer negotiating the format of communication. It is enforcing it. What we're seeing here is a structural correction attempt. The court trying to bring the interaction back into a legally functional format.
What is the bond for your client? $250?
Cash, that's correct.
Argument.
Judge, my client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. Obviously, it's a serious case, obviously. But it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does, but the court doesn't have to worry about tether. I'm just asking for a reduction in bond. to either a high part, some type of 10% bond. I think 250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe. Individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But, Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And Your Honor, with all due respect, the way that the people see this defendant based on previously being charged, now being charged with another CSC first degree.
As the situation escalates, something unusual happens. Additional judicial personnel become involved. This is not typical unless the proceeding is becoming difficult to manage in real time. When multiple magistrates or officials begin participating, it usually signals one of two things: either procedural complexity or behavioral disruption requiring reinforcement of authority. What stands out here is how the courtroom adapts. Instead of slowing down, the system increases pressure. This is the legal system essentially saying, we are moving forward whether the narrative cooperates or not.
I haven't heard their arguments of counsel. Where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old. Who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34, starting the relationship with the 15-year-old. Allegedly, she talks to a friend and they come over and the 7-year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts a person asking who is this Kevin guy, because her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds, and whether there's sex there or not sex there, we have a pattern that's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers, and so we're real concerned about this. So the $250,000 bond is an unaffordable bond, and so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts the bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million. Got him. And that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tether. Mr. Pollard is not to have any interactions with anyone under the age of 18, whether they're family, whether he knows them. He's not to be around anyone under the age of 18. If he is, that will violate this bond. Thank you.
So, Judge, the bond was $250,000 cash.
Yeah, and now it's $1 million cash. Now it's $1 million cash. Okay. It's $1 million now. It's $1 million now. Okay, because he's on Social Security disability now. Can't afford it. I understand, but the court finds that Mr. Pollard, it may be some serial action is going on right here, and I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure that Mr. Pollard is not able, at least right now, to be able to engage or even be charged with engaging in these type of activities.
Yeah, no, Judge, I get it. I know it's rough when the allegations are from January of 2020, but the prosecutor doesn't charge until January 24th. I mean,
Now we transition into one of the most serious phases of any criminal proceeding, bond determination. This is where abstract courtroom behavior turns into real-world consequences: freedom, restrictions, and financial conditions. The prosecution paints a highly serious picture, emphasizing risk factors and prior allegations, while the defense attempts to frame the situation as older, disputed, or contextually misunderstood. But at this stage, the judge is not just evaluating arguments. They are evaluating risk. And risk assessment in court is heavily influenced by perceived pattern behavior, not just isolated incidents.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249. I'm standing in for the Attorney of Record, Assistant Prosecuting Attorney Erica Moses.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. My P number is 58961.
All right. What's your pleasure, counsel? Oh, Mr. Pollard, unmute yourself and tell us your name, sir. Mr. Pollard, have them unmute you so you can tell us your name. Tell me your name, sir.
I exercise my right to remain silent.
You don't want to tell us your name?
I'm the beneficiary.
Beneficiary of what?
Of the trust that we are now here to administrate.
Okay, that's fine. Can you tell me your name?
Excuse me?
Can you tell me your name?
The beneficiary of the trust, Your Honor. I'm not
beneficiary of trust.
I'm not here. I'm not summoned here as the name. I'm summoned as the state trust. It'll be a contradiction.
I'm looking for Kevin Pollard. If he's not here, I will capious him.
Your Honor, you are appearing as Kevin Pollard today.
No, I'm not. My name is Kenneth King.
No, Your Honor, you are the trustee of the administrate, the trust that we are now here to administrate. It is a
I have no idea what you're talking about, sir. I'm just looking for Kevin Pollard. If you're not him, then I'll issue an arrest warrant for Kevin Pollard because he's supposed to be here.
Under trust law, it's a contradiction for one to be the beneficiary and the trustee, Your Honor.
All right, you're talking a different language to me. I have no idea what you're talking about. Miss James, how would you like to proceed?
Judge, originally I was going to ask that it be set for a preliminary examination, but it sounds like it may be a competency issue. So Judge, what I'm going to ask the court to do, I have an appointment to meet with Mr. Pollard this afternoon. I'm going to ask the court if you would, we can set an exam date, but we could also set Monday as a review date.
Hey, why don't we just do that before we set an exam date?
Okay.
The court will adjourn the probable cause conference. If you're able to find Mr. Pollard, we'll adjourn the probable cause conference to February 5th at 8:30.
Yes, Your Honor.
Find Mr. Pollard, and I will issue a casus for his arrest. Thank you.
Yes, Your Honor. Thank you.
As the judge moves closer to a decision, the tone becomes more definitive. This is the point where courtroom debate stops expanding and starts collapsing into a ruling framework. What's important here is how prior arguments, both from prosecution and defense, are weighed into a single structured outcome. The judge is no longer reacting emotionally or conversationally. They are synthesizing risk, allegations, and legal standards into enforceable conditions. You can also see how prior behavior in court indirectly influences perception. This case ultimately highlights a powerful contrast between individual defiance and institutional structure. On one side, a defendant repeatedly challenging identity and procedure. On the other, a court system that gradually tightens control until a formal legal outcome is imposed. Regardless of the arguments made during the hearing, the court's responsibility is clear: assess risk, apply legal standards, and ensure procedural order. The result is a high cash bond, strict monitoring conditions, and significant restrictions moving forward.